All right, so today's topic is on condos. And I think condos are, it's almost like that four-letter word because a lot of people don't really understand. There's so many different facets of this and what to worry about and what not to. There's the what you have to do, your tasks. If it's a condo, there are these added steps that you have to add. But there's also some legal issues. There's this whole different financial review. He wanted to come on here because he wanted to talk about some of his challenges with it being a condo and some of the quick advice that he might have when it comes to that. And so I wanted to start the simplest thing, which is, what is a condo? What is a condo? And the simplest answer is you kind of have three different types of ownership here in Florida. And, give me a little leeway because I'm sure some smart person will remind me there may be four or five, but I know of three. It's fee simple, which is the best type of ownership. That means you own everything. You got the whole property and whatever is built on it. Fee simple, you have condos, which is you own the unit, and then you own a proportionate share of all the common elements. And the third one is a co-op, which is you kind of own a lease and you're a member. It's something that we inherited from, I'm guessing, New York. When this area was getting developed, all the New York lawyers were coming down and saying, we should do co-ops. And it was probably before the condo statutes were formed, and we're seeing a lot less of those. Wouldn't you say, Dad, that co-ops are less than 5%, maybe even less than 1%?
They don't do new ones. There's practical problems with them. People don't understand what they are, and if you don't understand what they are, it's hard to sell. Also, when they first implemented them, the law in this state was different. It was not considered real property, so you could do things with a co-op like you could in New York, and you're right on with New York, that you couldn't do with a condominium or a regular standalone house. So co-ops were sort of, something where, you didn't have to worry about homestead back in the day, but now you do. Now there's been case law saying a co-op is in fact an interest in real property and all the homestead rules apply. So people just don't do it. In substance, is really a condominium in reality, but they use different paperwork and it's a different statute.
Well, and to that point, Dad, we have in town, what is the one association that by all other accounts, it probably should be fee simple, but it's actually a condo? Naples Bath and Tennis. I think.
Oh, that's the one that your brother lived in. That was Jack Bruger was the attorney who put that together, and they didn't have the HOA statute at the time Jack did that. So he had a condo within a condo. That's the structure over at the Naples Bath and Tennis. The master condo functions as the homeowners association. In reality, Jack was very creative. I think he's still practicing. And your brother's condominium actually was a standalone house. So
just a typical single-family home. And so did he have just the one condo association that he was a member of?
He had two, and someday you'll experience this, but doing a closing for one of your own kids is not the most pleasant thing in the world, and especially when he's a lawyer like your brother is. And then to have Jack Bruger come, but it was very creative. I mean, Jack is an incredibly good lawyer, but he was before the HOA statute.
Yeah.
So HOA statute's a new thing. The condo statute's been around since I was in law school.
Well, and when you think of associations, the primary purpose of them is to share expenses on common elements. That's the key.
And you have common elements.
You could use a condo, you can use it as a HOA, you can use it as a shared wall agreement. I've really seen them all. And where I used to practice in Atlanta, and we had a lot of shared driveways. And you wouldn't establish a whole HOA for a shared driveway. You would create a couple-page document that says we'll share in the cost and upkeep of the driveway. And that's essentially what an association is, but it's big enough that you can create committees and you can have a budget and lien rights and all of that. And that's what we're talking about. So when we talk about condo versus HOA, the key is, what do you own and how are the legal documents set up? And then we kind of go from there. What is funny to me is when you market properties, people use all different kinds of words. They don't always use condo. They may use villa, townhome. I mean, for you and I, how do you?
Well, the thing that you're describing drives me nuts. So I had one recently where it was a single family residence and it was in a condo. The problem with that is there's no FHA approved condos in Collier County. So that takes that loan off the table if it falls into those parameters of this, obviously the loan size. So it causes an issue as far as that goes, which then makes our ratios lower for qualifying, where you can qualify for more house on an FHA property, and a villa is fine. The key is to go, and Collier County has a wonderful website, the Collier County Property Appraiser website. You go on there, you look up the address, it'll even autofill most of the address for you. They're so easy to find. You go right in there and it'll tell you how it's zoned. If it's a condo, if it's a villa, if it's homeowners, whatever it is, as long as it doesn't say condo, I can do an FHA loan on it. If it does, I can't. So it's just a different animal.
Well, and you're right. Going on to the property appraiser website is key, because you can immediately go and you can look at the legal description, and the legal description is very, very obvious. In fact, if someone who's viewing could send us a message and give us an address, give us a condo address, give us a single family home address, and I'll show you how I search it and how easy it is to determine condo or not. And that's really what we're looking at, condo or not. So I'm gonna wait for someone to answer that question or to give us that information, and then I'll show you how I would search that. All right, so we've kind of figured out we need to know that answer first. And the reason we need to know that answer is, what do you do next? Because the Florida statutes are so I don't know, they have statute.
Damn lawyery.
What was that?
Lawyery.
Yeah, they're extensive, right? So they've got an HOA statute, they have a condo statute, and you have to follow different rules depending on which one it is. So what I'm going to do is I'm going to show you the form for, or first I'll show you the statute. Here is a statute. 718 is for condominiums. You or your client can go right to this statute and you can look at how these things are supposed to be done. Some of the things that you guys are probably, let's see, I can't even find it. I'm not sure which location it is, but I was saying one of the things that is in here is that 3-day condo review period. You're not going to have that same type of review period on an HOA. It's actually a little bit different.
I think it's around 503, Chris.
7. Let's see, 503. Let's see if I can find that.
I think
that's the developer
residential.
So filing prior to developer residential.
A little lower.
It's in this area.
Here we go.
For disclosure. See, you can actually tell this language.
It's part of this statute.
Yep, it's right in this area. We're close. We're very close.
You're in the developer part in the beginning.
That's the developer part, and then they go to the resale part. So basically, the statute then tells us what we need to do. So step 1, you verified it is a condo. All right, now we're in the condo statute. We've got 3-day right of rescission on condo review period. So by the time the seller gives the buyer all the condo docs as defined in the statute, the buyer has 3 days from receipt of all those documents to back out of the deal under their rights under the condo review period. That is statutory. They have every right to do that, and they can't waive it because that's their right under the Florida statute. So that's a big deal. We had a couple of deals in the past 12 months where the buyer actually used that to get out of the deal for other reasons. So if you were to fail to give an amendment to the declaration or to some covenants, the buyer might be able to pick that out and say, I want out. I never got the full documents. And that would be their right under statute. And we want to avoid that at all costs. So we'll talk about, after this part, we'll talk about what a listing agent may want to do, what a buyer's agent may want to do as well. Now, the next part is there are different forms. There's a form for HOAs and there's a form for condos. And we have a couple of them on here. So Kent, can you see the condo form here?
I can.
Okay, good. So this is the first one. Now, the important part is that this form is not unique to NABOR. It's just that, actually this one is, I'm sorry. So this one is unique to NABOR. And what I like about it is it gives you guys a table of contents. It gives you the roadmap for what documents are to be given to a buyer. And they pull this stuff directly from the statute. So we're saying, all right, Florida statute requires that the declaration of condominium be provided to the buyer. Articles of incorporation, bylaws, rules and regulations, the most recent financial information, question and answer sheet, and the governance form. So a seller is obligated to give each one of these things to a buyer. And then they also took the same stuff and they went over and they did it for cooperative documents. So if you are in a cooperative, you would use the right side of this form. Now, the interesting part of this form is that usually as a listing agent, you want the buyer to sign this. You're like, sign it, sign it. I've given you the disclosure, please sign it. And you'll get peppered to sign it. But they don't have to. There is nothing in the statute that requires a buyer to sign this form. But I talked to someone this morning who said, look, we got all the documents. Just as a show of goodwill, I'm willing to sign it. My 3 days will start, and that's fair. They're not impinging on my constitutional rights. So, but if you were doing a deal in Lee County and they're not familiar with this form, they may not sign it. They may say that's, we're not using that or something along those lines, but it does give you the roadmap. So as a listing agent, you're going to want to check off, did I do this and when did I give? Did I do it? When did I give it? And I would make notes. I think it's a really good form to use as part of your checklist, no matter what county you are in. Now, separately, there is a homeowners association disclosure, and it is wildly different. On this form, we actually have fees that you would fill out so that you can share it with the buyer. So important note up here at the top, a separate disclosure summary form should be completed and signed for each homeowners association governing the property in which membership is mandatory. This form should not be used to disclose membership requirements and assessments and other fees imposed by condominium cooperative associations. So the form is not meant to be used with a condo. And this is where it's really important, that first step, condo or HOA. Or do you have one of each?
And real quick, and I'm sorry to interrupt you. It's really important to do this, especially if there's going to be a loan on the property, because if not, we're going to be coming back to you later for it. And it just gives not only that, it gives the buyer a more accurate assessment of what their costs are going to be, especially if there is an assessment, and what their quarterly fees are and dues and whatnot.
Well, and Kent, you make a really good point. As a lender, you love to have this. As a buyer, you love to have this because it's really important to know what your costs are. But the funny thing is, if it's a condo, you're not going to use this form. And I'm sure Kent would still love to have the fees, and the buyer would still love to have the fees, but you don't get the fees on a condo. You just get the documents. Is that right, Dad? How do you kind of interpret that?
That's absolutely right. That there's nothing in Chapter 718 that requires a summary form on condominium fees. Now, obviously, if you're a good realtor, you want your client to know what the heck they are, and you can do that in an email, a cover letter. You can link them up with the management company. However you want to do it. But, with condos, you give forms, not, fees and the summary information. And with HOAs, you could just give the form and you don't give the documents. They're totally different.
With condos, we've had to actually have them send us a bill.
Yeah.
Oh, that's cool. So you would have to ask the listing agent to provide you a bill, some recent statement so you can see what the monthly is.
Yep.
Well, what else do you do, Kent? Because you're obviously needing this information for disclosure purposes. You need to be able to
for qualifying purposes too.
Qualifying purposes, very important. The sooner you have this, the more likely you'll know if you've got a deal or not.
Absolutely. Yeah.
So, but
big
you're
thing-
also asking those questions of the property manager, isn't that right?
Yes. Whether they answer or not is another it's another story, but usually they will cooperate if you ask in the right manner, and they probably will charge you a fee, but it is what it is.
Well, and it is what it is. And so knowing that a buyer is going to want this information, a seller is going to need to provide it at some point. I think a really good listing agent have this stuff pulled in advance of listing the property. You know, while you're not under pressure of a pending contract, and you kind of have the ability to kind of really think this stuff through. This would be something I would add to my list as a listing agent. Get all the condo docs, get, you know, the HOA disclosures filled out, and have all the fees. And you know, you can contact
It's one of
us.
the tips. It's one of the tips, Christian, that I always tell listing agents: do this up front, especially on a condo, because if you have all the condo docs and you have this information, and you put it even in your listing that you have all that information, it makes your property more marketable.
It does. Well, it also makes, you're not going to burn out your seller with a buyer, and then you have to struggle to find everything. You're going to have it really tidied up, and your buyer is going to know if they're qualified or not. You know, if you have $1,000 swing monthly on assessments or you know, whatever it might be, quarterly maintenance, it could really affect the qualification of a buyer, especially if we're coming into a market that's not as seller friendly. Yvette actually gave me an address, and so here it is. This is public record. Here is the property appraiser website in Collier County. Lee County has almost the exact same data, just has a little different format. But Kent, is this a condo?
Right there under,
not?
It's a condo right there in the legal.
Look at our legal.
Even though it's a mobile home, it's a condo.
Even though there's no unit number. So it makes sense that you're gonna go in, you're gonna look at this, and you can say, I don't know, it's just 35 Covey Lane. That's doesn't, you know, there's no unit number or anything. Even my brother's property, which we talked about, it didn't have a unit number, apartment, or anything of that nature. But the legal description is very clear. I might need to share this differently. So let me show you.
And in that instance, being that it's a condo, in that instance, because it's a mobile home, it's probably the lot that put it into a condo association, which is
and that is a whole separate topic. I think I will get myself in trouble if I start marketing for mobile home sales. You know, these are tough deals. These are very challenging. But if we focus on condominiums specifically, and we look at our legal description, here it is, Unit 35, Quail Roast, Unit 1, a condominium. It is very clear when it's a condominium because of where things are recorded and how they are recorded. In fact, if you keep reading, according to the declaration of condominium thereof, as recorded in the official records book. So if you have something that's maybe in an HOA or just on its own, so if you were buying something, say you're buying something on Marco Island, they have Unit 13, you know, that's what the plat was called, Unit 13, Marco Beach, whatever it might be, but it never says condominium. And then you compare it to a legal description like this, and it says Quail Roast, Unit 1, a condominium, according to the declaration of condominium thereof. It becomes very, very clear that these are two separate things. And you're really going to have those two options. And I'll show you another one later that has that same thing. Dad, anything else you could point to on a deed like that?
The big thing with the HOA summary disclosure is if you don't do it, the buyer can void the sale, can terminate the contract. You want to keep your deal together.
So that let's dig into that for just a second, because I wanted to focus more on the condos, but we focus a lot on condo 3-day right of rescission and not as much on the HOA, but that same rule applies. The seller is obligated to disclose the fees, and you can use that form. You can disclose it another way potentially, but the seller has an obligation to disclose, and the buyer has the right to review that. Now, if you say, I'll get you that form later, that makes it gives the buyer the unilateral right to terminate. And we really don't want that. We want the buyer to have all the information day one so that you don't have that unilateral right to terminate. But in a condo, you kind of have that. You're going to have that for as long as that 3-day period could last.
Kristen, do you want to
Interestingly,
see one? Do you want to see one that has a unit number that's not a condo?
yeah, let me share my screen and we'll find another one.
Like I have an address for you. It's
All right, go ahead.
4704 Lakewood Boulevard.
Where you live,
There you
Kent?
go. Sorry?
All right,
No, but you'll see. See, it says use code homeowners. And it's a villa. It's attached. It's got a unit number, lot. That's not a condo.
this is not a condo. Let's look at the legal description. Lot 12, Block K, Lakewood Unit number 6. You might be turned off by that unit number 6 thing, but don't let it distract you because then it just says Lakewood Villas. It does not say a condominium. And then it references the plat thereof. If it was a condominium, you would be referencing the declaration of condominium. There are other ways to do it, but then if you look even further, they actually give us the meets and bounds. This is good stuff, Dad. Look at this.
Yeah, I don't miss those at all.
Commencing at the southeast corner of Block K. Yeah, and so what it's highlighting to you is here are the property lines. And obviously on this property, it's not a square. It's not a perfect square or a perfect rectangle. If you had a condominium, they would be referencing the declaration of condominium, which included in that are blueprints of the units. It almost looks like a sales brochure in a certain way. So it is different. And if you ever have questions, if something is confusing you, please just reach out to us directly or phone a friend, because that would be something important for you to make that distinction. Which form do I need? Now, could you have both? Yes. Let's take Laley as a good example. You could have a condominium association that is part of a master homeowners association. So you're going to fill out the condo receipt and get all those condo docs, and then you're going to fill out the master HOA with the quarterly fees or the annual or the special assessments. And then you might also have a golf membership. Dad, what's your take on whether you should fill out an HOA disclosure for a golf membership?
I wouldn't do it. I would put it under other terms and conditions or some sort of addendum to the contract. There's some controversy over whether if you deviate from the HOA summary disclosure form, that it's no good. There are lawyers in town who take that position. I've had lengthy debates with them over it. So you just give that form is pretty much directly out of the statute. You want to play it safe and give them the form so the buyer can't terminate. And any extra information that any good realtor would be giving to any purchaser, you can either include it in the contract, you can put it in the seller's disclosure, you can put it in MLS, make sure it comes from your client. We've had people get upset because the TV bill was $10 a month more than they thought it was. So you get the information from the client so you don't get blamed.
Well, and then the other thing, Dad, and actually Kathleen mentions this, she says, condo Q&A typically has the condo fees listed. It should. We love it when it does. Sometimes they don't get updated enough. But what we love even more is having your buyer go and apply in person. Most condo associations down here do have an application that is mandatory before they buy. And your contracts require the buyer to do that at the beginning of the contract. Otherwise, they could be in default. So you kind of kill two birds with one stone. You go down, you meet the property manager, you ask about fees, you look around, you see if anything is being constructed on, is there anything going on that we need to know about that you can't figure out from being elsewhere? You can't have, a lot of times the agent will just drop off the application with the check, which is great. It's a service you guys offer a lot of times, but even better is the buyer going in person because there's a lot that they could maybe learn from that experience. Dad, that rolls me into the next one, which you've had a lot of experience, and specifically you dealt with this yesterday, condo docs. So now we know it's a condo. We know we have to disclose using the condo docs. There's that list and you get the receipt. And now you're a buyer or you're working with the buyer. They've got 200 pages of documents, their favorite thing in the world, all this legalese. What's your general advice? How should an agent talk to their buyer about reading this and understanding it to the best of their ability?
Number one, don't sign the receipt until you have either you or a lawyer review it for you. For the ones I was doing yesterday, as you know, they're good friends of mine. So I read the documents. With the declaration, I always focus on the use restrictions. Those things are customized typically. The rest of it is statutorily required. So the use restrictions will get into, pets, what kind of cars, rental periods, when your kids or friends can come down and use the place when you're not there, which is a growing thing. So the use restrictions, then, yesterday we were looking at how much money they had in the bank. We're in January. They may not have the most recent year-end financial. The most recent year-end financial might be 2021. So you could be 13 months old and we had a hurricane. So, you ask how much money we have in the bank. Look at it like it's a human being. Are they solvent? Do they have any insurance claims, any special assessments they're talking about, damage from Ian, things of that sort. And then the rules and regs, which are their day-to-day use of the property, hanging things over the railing, keeping the garage door open, putting a basketball hoop out in the driveway. The little things drive people crazy. So I really urge the clients, read everything, but don't miss these areas is the way I do it.
Also, I want to add something to what Don is saying, and not only that, yeah, budget and stuff like that is very important, but also delinquencies is something that has come up. So that's actually causes sometimes a place to be non-warrantable because of a certain percentage of delinquencies on HOA dues.
We had that in 09 and 10 when everything was going upside down. The delinquency was a big highlight. The receivables, the receivables. If it's a big number, they got a problem.
Yeah. So I bought a condo in Atlanta in 2015, 2014, and I looked at the financials and it showed that there was $1 million in reserve. And I'm like, well, my dad's always told me just make sure there's money in the bank. And I'm like, $1 million sounds pretty good. Well, what I realized is that $1 million for 350 units is like nothing. If they had a major issue, if they need to replace the roofs, they're going to have to do a special assessment. So really it depends on the size of the unit, of the complex, what kind of construction, how old things are. Delinquencies are really important because it tells you, has this community had some financial difficulties and they're playing catch up. And we'll talk a little bit about that when we get into the engineering reports that are going to be required as well. Melissa, you have an awesome question. Would doing an amendment or an addendum to sales contract work for condo fees? It's a slippery slope, and I'm probably going to recommend you avoid it. And it's for this reason. The positives of an addendum referencing, quarterly assessments are X and annual maintenance is Y. I think that's really helpful, but it's a slippery slope in the event that it's not complete. So if a seller were to disclose something that to their best of knowledge is right, but then those fees were to change, all of a sudden the buyer could feel like they got a bait and switch that, and they might try and cancel the contract. They might say that the contract fails because of that disclosure. They could even claim fraud or just negligence. I'm not sure. I just don't like it. What I would prefer is that you hang your hat on the condo receipt. You disclose. You advise the buyer to go in person, even if it's not your client. You tell the buyer's agent, make sure you go and meet with the property manager, ask all your questions, ask about fees, get the financials, and just encourage them to do the work for them. And if they say, well, do you know generally what it is? Sure, of course I do. You could send it in an email. You could just call them and say, all right, get a pen and paper. Here's what I know the fees to be. My client says that it's $1,200 a quarter and they have to pay the water separate. That's really great. That way it's not part of your contract, but you're being friendly and trying to build goodwill and helping the buyer. And then if Kent calls and says, hey, can you remind me what those fees are? You tell him, or do what I do and block his number. So be careful.
I've had that happen, Christian, where the fees went up between the effective date and the closing date. And what I generally tell people is, I spoke to so-and-so, here's his name, here's his phone number at the association. He says it's this. please call him at this number and verify it. And then you can ask at that point, is there any talk about increasing the fees? Are there any special assessments in the pipeline? Any other financial issues going on that, you might want to share with me?
Yeah.
That sort of thing. So I always confirm with my client that they're going to verify what I was told.
Exactly. And actually, one of the most powerful things that I've found a buyer gets is when they go and talk to the president of the board. So it's not by design, but they go to the property, they go to the walkthrough, they go to apply in person. And
Right.
one of those things, or at any of those things, they run into someone from the board. And that tends to give the buyer all this comfort or distaste. It's usually it's comfort though. And they say, I talked to the board president and he's thinking it's maybe a $1,200 assessment that's down the pipeline. So I'm not that worried. And I'll say, that's great. That's awesome. Without that connection, without being in person, then, they're kind of hanging their hat on whatever it says in the documents, which it could be somewhat limited, especially given what my dad was talking about, that the year-end financials aren't available and we just had a hurricane. That, there's a gray area that we're just not aware of. We have a couple more questions. I love these questions. This is great. So some listing agents refer you to the condo website for the condo docs. Contract states the seller must provide should one insist on delivery from the seller. I love that question, Kathleen, because the listing agent failed to actually give them to you in that scenario. So if I'm representing a buyer and, I want deals to close, I like it when there's open communication and that the buyer has all the answers and the seller has given them everything and that the deal works. But if you're representing the buyer and you can find the documents on your own, but you insist that the listing agent provide them, I think that gives the buyer everything we want. It gives leverage. It allows the buyer to say, the listing agent or the seller did not disclose the condo docs per my rights, per the Constitution of Florida, and therefore I have the right to terminate if I want to. It turns it into an as-is contract for the life of the closing. For up until closing, I could back away if I want. In the meantime, we usually can get the condo docs ourselves, especially if it's an association that you're familiar with. So I don't know if I'm clear enough on this one, but I do think that that is a mistake on behalf of the listing agent. The listing agent should absolutely have condo docs, disclose them to the buyer, and verify that the buyer has received them either through the condo receipt or via email or otherwise. Because without actually giving them to the buyer, buyer could terminate with, under any reason that they want. And that's probably not what your seller hired you for. That would be my guess.
Christian, I agree 1,000%, but here's an additional layer to the whole equation. Oftentimes you're provided condo docs by the seller, or they'll give you the link for the condo docs. Meanwhile, behind the scenes, you're getting your own set of condo docs to see if they match up. Because quite frequently, as you know, the documents we're provided with are old. They could be 30 years old. And most frequently, they've been restated. If they're 30 years old, the statutes have changed, cases have come up, the rules and regs have changed. And in one case, I got like 19 amendments to the declaration that were not provided with the initial delivery of documents. So many times the documents just look incomplete. They might be missing key aspects, and we just double check.
So we got another email or another question. The property manager and a resident realtor insist that a certain property is a co-op with an HOA. What can I show them to prove it's not an HOA? Well, honestly, what I would probably recommend is that you reach out to us, contact me directly. My email is christian@rosstitle.com. And I'll research it and I'll give you all the firepower you need to say, all right, this is an HOA, this is not. And we have to do title exams. We probably have done a closing there in the past and we can give you a heads up, but yep, this is an HOA, this is a co-op, or it's not. But when you're getting pushback, lean into us. That's what we're here for. Whether it's a closing that is under contract or you're just kind of kicking the tires on it, let us earn your trust. This is something that we're good at and we can help you with. I love that. we do have another one. Listings from last year don't reflect the new association fees, as listing agents might not have the info yet or forgot to change it. Especially now with insurance increase, we need to be careful. I couldn't agree more with that sentiment. In fact, my dad and I just did a very large closing. It was over $5 million. And the association changed the monthly assessment. I think they doubled it from December
Was that
2022
Mediterra,
to
Christian?
January 2023.
Was
Was
it
that?
Mediterra? I just did one. Was it in Mediterra? I just had one. It was the same exact thing.
Yeah, and so actually we got an email from the buyer's attorney saying, can you disclose, when this change happened? And I think what they were getting at is they wanted to see, did the seller just do a really sloppy job of disclosing, and this has been the fee for the last 12 months, or is it literally brand new? And they were looking for a reason to pin us against the wall, which luckily we weren't trying to hide anything. They changed it like 3 days before they even asked the question. But that was a fun one. That's normal. I think that's pretty common. And when you're getting into these big numbers, it matters. And we're trying to keep deals together. So if we can help by you contacting us earlier on, we'd like for you to do that. All right, Kent, Dad, this one's the fun one. Last summer, Florida passed a new statute regarding engineering reports for condominiums that are three stories and more, or more than 3 stories? We'll figure it out.
More than
3 stories. Thank you. Hopefully. And then that are 30 years or older, they need to provide additional reports as to the structure of their buildings. And if you live within the coast, I think it's within 3 miles of the coast, then it's within 20 years. So if your building is more than 20 years old, then you're subjected to these reports. And unfortunately, it's a brand new statute. We haven't gone through a season where these things have been updated. We're not exactly sure what the state is going to be expecting as far as the format and the extensiveness of these reports. And then we also don't know what the state's going to require in return if someone were to fail something. So let me show you what we do have. There is a form, and it is on Neighbor. So if you guys want to see it, you don't have access to this, you just let me know. But this does a really good job. Let me just quickly read it for you. On July 1, 2022, Florida legislature enacted legislation for consumer protection and safety requiring periodic inspections of the structural integrity of a condominium and cooperative buildings, which are 3 stories or higher. 3 stories or higher. So
it's 3 or higher. Okay.
3 or higher. There we go. Specifically, a structural milestone inspection, which is a made-up term. No one knows what that is. Is required by a licensed engineer or architect when the building is 30 years or older, or 25 years or older for buildings within 3 miles of the coast, with updated structural inspections to be conducted every 10 years thereafter. Both the milestone inspection and structural integrity reserve accounts are important measures for consumer safety and protection. These measures may have a financial impact on assessments collected or to be collected in the future from owners, as well as on the ongoing cost of ownership in these affected buildings. Buyers considering the purchase of a condominium or co-op in a building affected by these new regulations are encouraged to discuss these matters with any other questions with the condominium or cooperative association and buyer's legal, financial, and other professional advisors prior to entering into a sales contract. This is a disclosure. This is a heads up. By the way, in case you know, my thinking is if you do a closing for a buyer or a seller, this form needs to be included when it's a condo or a co-op. It's part of your checklist. If you have the condo receipt on your checklist, you also have this form to be included to get a sign off on it. If you didn't have it, you'd probably be okay. But the key is disclose, disclose, disclose. Maybe a buyer's not familiar with this. There's still a lot of questions out there. We're not exactly sure how to answer them. But generally, all these condo associations and co-ops are going to have to hire engineers or architects to do annual, or I guess every 10 years, a report regarding the structure of the building. And if there's any deficiencies, they're going to have to act on it or risk losing the occupancy of the building. Now, Kent, you've been thinking about this for 6 months. In fact, I think you might have been the first person that even warned me about this originally. How do you interact with this form? What does it make you do?
Well, so everybody knows, this came about because of the Miami towers that fell last year. So that caused them to go, well, wow, yeah, there was a structural problem. There wasn't ever an inspection done. We didn't know there was a structural integrity problem. When you buy a single family residence, there's an inspection done, and you'll find these kind of things. And that this wouldn't happen on a single family residence necessarily. But with that condo, it did. It collapsed. A lot of people perished. It was terrible. This should have been enacted a long time ago, but it wasn't. But now it's good to disclose this, because even if you don't send this disclosure and there's going to be a finance on the property, we're going to request the questionnaire has an addendum to it that they fill that out and ask if this has been done or not. If it hasn't, nobody's going to lend on it. So
Yeah,
it's obviously good to disclose this. You're going to want to do that, but we're going to want to get the questions from the association as well.
Yeah, so let me kind of break down the kind of the curtain over some of these things and how our companies interact and get you to an actual closing. So as the realtor, you guys are helping your buyer or seller disclose these fees and fill out the proper paperwork so that the buyer knows what they're buying. And then separately, my office is doing the same thing. We reach out to the condo association or the property manager, and we ask them, can you please confirm what the fees are? Can you please tell us if the seller has an account balance, either positive or negative, and let us know what obligations are for the buyer to actually buy the property. And then Kent does the same thing. He sends the property manager a condo questionnaire that he needs answered. So all three parties are wanting answers from property managers. No surprise, property managers all hate us.
That's not just us. That's a Fannie Mae, Freddie Mac rule.
I'm not picking on you, Ken. Every lender needs it. It's really important, because if we're lending on someone's credit worthiness or their affordability, or we're lending in a condo that we don't know anything about, we need these answers. And now Kent has added this new addendum. Fannie Mae, Freddie Mac has a new guideline regarding this new statute, and is the property manager and the condo association in compliance with it or not? Because if they're not in compliance, or if they fail to answer these questions, they're simply not going to do the loan, and you're going to lose the closing. Correct. It matters. It really, really matters. Someone mentioned that you couldn't see the form, so I'm trying to make it a little bigger. I hope that was somewhat helpful.
This is definitely something that they can ask about during the 3-day rescission period too. Have there been inspections of the structural integrity? A lot of these buildings are older.
Yep, absolutely. So Suzanne asks, would that apply to villas detached and unattached? So if we reverse, if we go back, villa is more of a marketing term. It's kind of made up. What we need to determine, is this fee simple, or is it a condo? So, or even simpler than that, is it a condo or not? If it is considered a condo by looking at the legal description, then yes, this matters. If it is fee simple, it does not. And going back to my brother's example, where he had a single family home that was a condo or in a condo association, it wouldn't apply to his home because he's not more than 3 stories. Correct. Or he's not more than 2 stories. So it might apply to villas. I know there are villas in Autumn Woods here in Naples. They're called villas. They have a shared wall. They are not condos. Separately, there might be a villa that is a condo. You have flexibility as the attorney, kind of how it was set up. Let's see if there are a lot of questions. I love this day. This is great. And we had about 50 people on today, so I really appreciate you coming on here. I might have to skip some of this stuff. Kent, do you have any other words of wisdom, things that you think about when it comes to a condo?
Yeah, I mean, the first thing that I always it's funny too, because, typically speaking, and I hate to keep bringing FHA up, but it's because people will qualify for more property because ratios are allowed to go higher on an FHA versus a Fannie Mae loan. So for instance, that one that I showed you earlier, that was not a condo. The sales price was $100,000 higher than a condo in a similar area. They qualified for that property and not the condo because of the condo dues are higher. and they qualify for lesson ratios. So it's something that I always look at. That the Collier County website, the Lee County one is good too, but that Collier County website is invaluable to go on there and look at, know what you're looking at. It's just, that's the first place that I go, not only for that, but for tax bills and everything else.
Yvette asks, how is the coast defined? And that's really funny. Yvette must have legal training in her background. My guess is they're talking about the Gulf of Mexico, Atlantic Ocean, not necessarily, Lake Okeechobee, but possibly. I could see that being a good argument. My thinking is property managers and condo associations will have to be on the more conservative side. And if they're within 3 miles of water, they probably need to be filing for this.
It might be the coastal control setback line, but I honestly don't know.
Yeah, I don't know. That's a good point too. Yeah, that's a very good point. Dad, we've had this conversation. Condos, you've written articles on this, and we have those available to people if they're interested in reading them after this class. But is there anything else that you might suggest to someone who's marketing a house on or a condo, that what they should do before they actually put it on the market, what they need to think about, and how to protect themselves? Because that's what we want to protect: the closing, we want to protect the buyer or the seller, and we want to protect ourselves. How do we kind of achieve those three key focus?
I would disclose everything. I would disclose past repairs. Things reoccur, and the more expensive the property, and all the properties down here have gotten more expensive, the more affluent the buyers, and they all have means, and they don't like to be deceived. So if you want to protect yourself, and you had a leaky pipe, which actually I have going on right now, disclose that you had a repair 3 years ago, and here's the invoice. And on the buyer side, get involved. I mean, call the management company. You're going to need the phone number anyways, and ask about the structural analyses, ask about potential special assessments, insurance claims, damage from Ian, and how the place gets along. Do they have social groups? Are there factions? Will you be happy there? My friends that you and I were talking about earlier, I recommended that the wife, your mother's best friend, go by with a bottle of wine and knock on somebody's door, and you'll get all the scuttlebutt in 5 minutes. I mean, it's going to be your home. You want to be happy.
Yeah, absolutely.
So there's a lot of intangibles.
Yeah, I had a phone call with a buyer this morning who is out of town. He's driving into town tomorrow. Closing is on Friday, and he's letting his anxieties get the best of him. And I think the biggest problem is that he's not here. You can't see it, you can't feel it, You can't meet with the board president, you can't ask the property manager in person. He's kind of getting the runaround, and it's kind of building up. So while your client is down here searching for properties, encourage that. I think there's a lot of information, but we kind of have to read between the lines a lot of times before we can make a decision on a more a bigger scale of whether we want to buy it or not. What's the vibe, and what's going on site sort of stuff.
Well, they actually may make friends when they go in and start asking questions, and they bump into the president of the association, and that makes it reaffirms.
You can make it a simpler deal. Absolutely.
It's more concrete. It's tangible. It's not some intangible thing that they're afraid of.
Yeah. One last point. I had a closing last year, and it was kind of a unique situation because the buyers wanted to buy this place as a vacation home. It was a condo, but they have young kids. They have like a 7-year-old, a 9-year-old, an 11-year-old. And they travel down to Florida for tennis, and they're really good at tennis. But when they did their review of the condo docs, it actually said no kids allowed. Now, this was not a 55 or better community. This was not a one of those federally allowable things. And in fact, we determined that it was a unconstitutional. It like raised the level where that's actually not allowed. You're infringing on my constitutional rights. And so what I told the buyer in that scenario is I said, I don't recommend you make a lawsuit out of this. What I recommend is you go down there and you say, hey, what's the vibe? If I have young kids, we'll use the pool, but we're not here that often. Are we going to offend a lot of people, or, what's the deal? And that actually solved all the problems, because in that community, they were so friendly and lovely, and they were so excited about it. And they had no idea that language was in there. Those covenants were 30 years old, and no one had read them in 30
And
years.
they're probably not enforceable. And I would also say put the kids on the application, because they always ask who's going to be.
Actually, that's a great point. Thank you. Put the kids on the application, put the dog on the application. Don't let your questions go unanswered. Put them right out there, because if you're going to get denied, you want to get denied during your contract, because then you could get out of the deal, as opposed to if you've already bought it. So let's finish up there. That was an awesome class. Thank you, Dad. Thank you, Kent, for joining.
Take care.
If you guys need to watch this afterwards, if you want to contact me directly, so it's youtube.com/Christian Ross, or you can email me, christian@rosstitle.com. Kent, what's your email?
Kent.williams@FDM Home, so Fidelity Direct Mortgage, FDMHome.com, or you can find me at 239mortgage.com.
Awesome, 239mortgage.com. Thanks, guys.
Yeah.
Have a wonderful